Please, your lordship. Well, I beg your lordship's indulgence to mention a matter. Well, there was a review petition filed which was listed on Friday last. But because of my absence from station, an adjournment was sought. And your lordship has fixed the matter for some time in the first week of June. The difficulty is that certain orders have been passed by the authorities requiring me to hand over charges. If your lordship kindly allows me to do it sometimes in this week, that would have been very, I'd have been very
Difficult. I have got one pending matter which I have to declare by this week, by Thursday.
Well,
That is taking a lot of my time.
your lordship permits me to do it on Friday, my lord, 23rd,
No, Friday.
or on 29th.
I'm not here next week. That's the thing. I'm not here next week. You see, the problem is if I didn't have one matter which I have to complete, there is a 6 months period during which I've got to complete. This is tribunal. So this is because it had come to the tribunal late. And there were certain procedures to be followed. Evidence is this thick. I have got to go through that.
The matter is otherwise very
Maybe,
small,
but
but
Mr.
it is only 2-3 documents that could not be produced.
I don't have time. And you should have come on that day. You should have made someone, you should have, you see, we come prepared. And then we all suddenly at the last minute, you all say you all don't have time. And review, though, I take it very seriously because it's a review. And I don't like to keep things pending. You all did not come. You all should have at least given a mention memo. No one turned up also. That's not the way. You wait.
May I please, your lordship?
Yes.
Lordship, item number 10, we have filed an additional affidavit. I may be allowed to call.
Item number 2.
2 years.
Concern of the other side, lordship, may the matter be taken up on 27th of May. For the petition.
Okay. Any objection? Who are you, madam?
Lordship,
Name?
S. Sharma.
Miss S. Sharma appearing on behalf of
Mr. B.K. Singh.
B.K. Singh, Learned Counsel for the FCI. Prays that the matter may be listed on 27.
Yes, lordship.
The same not being objected to by Miss S. Todi, Learned Counsel for the petitioner. This is the matter on 27.
Obliged, lordship.
The respondent number 3 has filed their affidavit in item number 3. I need to file my reply. 1 week, 10 may become.
Okay, right. Mr. Ardhar is granted how much time?
1 week.
A week's time to file affidavit in reply. This is the matter.
30th of May.
Huh?
30th of May.
This is the matter on 30.
Obliged.
Item 9 for your.
Okay, right, Mr.
J. M. Sulaiman, on behalf of yes,
Mr. J.
M. Sulaiman.
J. M. Sulaiman appearing on behalf of Mr. A. M. S. Mazumdar, Learned Counsel for the petitioner, submits that instructions have been received to withdraw the petition. Who is appearing for the other side? Mr. M. Buyan.
For PWD.
Appears for the PWD. The prayer of the petitioner's counsel is allowed. The petition is dismissed as withdrawn.
Wait, please, my lords. My lords, with most sincere apologies, my lords. I'm praying before my lords to pass over this matter for today, my lords. As conducting counsel, Mr. Anse Katania could not come due to water logging in his area, my lords. No.
In this case, lordship, the FS proposal has been processed in the e-file, lordship. And the proposal will be sent to Finance Department for conference after approval of the company report.
Madam, do you know the order that was passed by this court?
Yes.
I have asked you for the letter sent by the health department to the finance department. I don't want the letter sent by the health department to you. Where is the letter sent by you by the health department to the finance department?
No, Finance Department, first of all, lordship, for proposal, A proposal, it will be sent to process in the e-file lottery to be processed.
To be processed by whom?
After that, it will go.
To be
the
processed by
appeal
whom, madam?
By the competent authority.
Which is the competent authority?
That is a higher authority.
What is the higher authority than the secretary?
Yes, okay.
You see, this letter is issued by the additional secretary to the government of Assam. That is the secretariat. From the secretariat of the health department, where should it go to? Where does it go to? It goes to the finance department. I'll tell you how it goes if you don't know. Your district office will clarify, send it to the directorate. Directorate will then send it to the secretariat. Secretariat then will then send, after making the proposal for sanction, it will send it to the finance department for sanction. Now, it doesn't go back to the director. It has to go to the finance department. So that is why you have written a letter. Your letter says, what does your letter say? Has been processed in file and will be sent to the finance department.
For concurrent. after
Yes.
approval of
So,
competent
so this is what I'm saying. Now, you are supposed to bring, so that means, as per the last order, you are supposed to bring the letter sent by the health secretariat
authority. Yes, okay.
to the finance department. You have not sent it till now.
Take some time, Lord.
Then the next date you produce it.
Yes, Lord.
Right. Ms. D. Bora, Learned Standing Council, Health Department, has submitted a letter dated 19/5/2025, which is to the effect that the bill of the petitioner amounting to rupees 19,98,080 has been processed and the proposal will be sent to the finance department for concurrence after approval of the competent authority is received. Good, sir. Next para. Who is the competent authority, madam?
Commissioner,
Commissioner.
Mr. Zone Secretary.
No, let us know that these are all delaying tactics. Please do not, we know how the government functions also. We have been a lawyer for a number of years. I've represented various departments in my private capacity. And I know how government functions. Please bring the letter on the next page. Next para. Ms. D. Bora shall produce shall on the next date produce the letter sent by the Secretariat of the Health and Family Welfare Department to the Finance Department for concurrence of concurrence for the sanction of the amount payable to the petition. List the matter on. When?
Next week,
When do you want next date? Tomorrow can be the after also. When do you want?
next week,
Not next week, we will give you some time.
tomorrow.
June.
I'll leave it to you. 60. I'll let you.
You before, after that, let me see. Again, 9th June.
I'll let you.
This case, unless they have filed an additional affidavit, that sometime, after some time, also an annexing the GCC. Today only, this morning we have received the additional affidavit copy. After some time,
Anyway, only thing you can, they will ask them to obtain instructions. No interim order. And the bank guarantee, you know the law.
Proper bank guarantee. Here, what happened, madam? The secret 2010, the work was awarded to us to be completed within a period of 14 months. Now, because of the fall.
2010.
Yes, that's what matter. And in 2024, we have submitted a representation saying that you invoke this force majeure clause and terminate the contract. They did not do that. Rather, they on 16/1/2025, they have extended my period of contract up to 31/12/2025. I have submitted a representation on 27% to their request, that these are the conditions on which I am going to submit the
Anyway, let them obtain instruction.
Till then, they have not yet acted. Okay, clause 62, for termination of one.
I don't know what 62 says.
Well, that, it is,
Mr. Gupta is appearing this matter, is received instruction.
Okay. After some time.
Much over.
Yes.
Lordship, we have received the instructions and on the basis of this instruction, there was a joint meeting that was
Huh?
held. On the basis of the said instructions, Lordship, a joint meeting was held under the chairmanship of the Commissioner.
A joint meeting.
Yes, Lordship, between the Commissioner and Secretary of the 380, then the Executive Engineer of PWD, as well as the Joint Resident Commissioner of the Assam Bhavan in Calcutta. And they're addressing the matter and they are processing the matter regarding this. And for this, regarding the pending bills, they're processing the matter. And it will take 6 weeks' time to properly.
Show me your letter.
Lordship. Very-
Okay, we'll give them 6 weeks. Let them arrive at a decision. Correct. Okay, Mr. M. Nath, then a senior counsel appears for the petition. Mr. M. Buyan
Lordship.
appears on behalf of Mr. B. Gover. He submits that 6 weeks' time is needed to process the petitioner's pending bills and take a decision on the same. In terms of the letter dated 14/5/2025 issued by the Joint Secretary to the Government of Assam, GAD, which has been addressed to Mr. B. Gover, Standing Counsel GAD. Next paragraph. The letter dated, the contents of the extract of the letter dated 14/5/25 issued by the Joint Secretary to the Government of Assam, GAD is reproduced herein below as follows. List the matter on. After 6 weeks, give a date. Sir.
Much better.
Limited amount of time. It is the option. Beginning of this matter pertains to the minimum wages, whether it is to be calculated on 26 days or 30 days.
Lordship, in this matter, Mr. SSO appear. I have told that he is on legs in some other court. Lordship will take up this matter after some time.
Let's see. You are here also.
Is for the private response.
So many books. You are scaring me.
That's the last day, minutes. There have been partially argued on behalf of the petitioner.
Who's for the other side?
Lordship, he's on legs in court number 5, so item 1.
Okay, let's do the other stuff. Sir. I don't. And you see, there's no point hearing you and then waiting for them.
Lordship has passed the matter for time.
Yeah.
Much better.
Which is the option? Lordship, in item A, I have received the file yesterday evening because I have now been newly engaged in item A.
Okay.
In item A, and I am in the process of filing the wakalat now. In file,
In item 8.
item A. In item 7, I think her senior is out of station. So accommodation is not followed.
So what do you all want?
Basically, not inconvenient, thank you on 4th of June. In fact, they have filed an IA also. We need to respond to that. You've received the instructions, we'll file the affidavit in the meantime. That IA has been filed in item 7.
Both of you motion day.
It has to be because we are yet to exchange the pleadings.
Okay, so you all will not be doing anything that day.
Item 8 also have to find the.
We are required to file our counter.
Okay, right. Counsel for the parties pay for time to file their respective pleadings according to this matter on 4th of the
Of that.
time being matters, we are going to start now.
Time being item 10.
Has the additional affidavit passed? No, the other side is not there, that is what to do.
Submitted.
Okay, what is your case? Tell me.
Well, as I said, 2010 contract was granted for construction of a tunnel in Mani.
Tunnel,
Tunnel.
one
For the-
tunnel, how long?
For the railway.
How long?
About 867 meters.
867 meters, oh, quite pretty long. Nearly a kilometer.
Had to be completed in a period of 14 months or so. Now we have started the construction. Then they have realized the alignment was wrong. So they have-
Alignment was wrong.
Wrong.
After constructing, after
While-
going through,
While the.
Halfway?
Halfway. So again, realignment, once they had the supplementary agreement, has been executed. And then, my lord, because of a landslide, the dispute arose between the, my lord, village authority and the government. So matter could not be, my lord, done, my lord. Then, my lord, work completely stopped from 2022. And thereafter, this ethnic class between two groups, nothing could be done. So we have submitted a, my lord, representation of 30th of, my lord, March 2024. My lord,
30th of March.
30th of March 2024. That it's a case of force majeure under clause 17. So under 61, you resign the contract. In that case, no person will be entitled to claim any damages from either of the side.
You signed the contract under which clause?
Under
62.
61. 61.
Of the GCC.
This is, I'm just supplying the copy, my lord. I have expected. Then, my lord, what they have done, they have extended my period of my lord pay contract by order with the 16/1/2025. Under clause 17(2), that is not for the default of the contractor, but for the default of the railway or for other. 16(1). But we were not.
Say 17.2 you said.
17. So we were not interested to execute work because of long pending, everything has been held. We did not do anything, that they have called us for a meeting on 27/1/2025. We were present in the meeting and then
27.1.
27/1/2025. Then according to their advice, they said that you give us a work plan so that we can do the things. We have submitted the work plan, giving certain conditions. They did not respond to that matter. Then they have been asking us to give the close traversal report. And this close traversal report, because the work has been abandoned close long back. So you have to reassess the entire thing by way of a survey with an expert and then submit the report from which point we'll be starting the work. And there was a little delay on that, but on 5/5, they have given me, given us a notice to submit the traversal report. Then immediately on 7/5, we have submitted the work action plan saying that by 20th of May, 10th of May, we'll be submitting the traversal report.
How do you spell that traversal report? Where is that?
That's, yes,
Where do I get that word?
page 54,
Okay, close
close traversing.
traversing. Traversing report.
Close traversing data, close traversing report.
So did you submit the close traversing report?
Yes, look, this was issued on 5/5/25 on 7.
No, because on 7 you have issued your work plan.
Work plan and saying that on 10th, we are submitting the plan. On 10th. 7/5, we have said that we will submit. There's no time limit within which period.
So when did you submit your work
We
plan?
have submitted ultimately on 12.
Work plan submitted on 12/5. And close traversing report you submitted when?
On 12.
Both on 12.
No, madam, this report.
Is the work plan
Work
the
plan.
same as the close traversing report?
Roger.
Is the same thing?
No, madam, it's a different working plan.
That is why, Mr. Council.
Right.
So, work action plan is different
Roger.
than a close traversing plan is a different document.
Roger.
Now, work action plan, when did you submit?
Madam, initially we have submitted.
Not initially, now, when did you submit?
on
Latest,
7/5.
7/5.
7/5.
And then when did you submit your close traversing report?
Madam, on 12.
Say that. You're
12/5.
confusing, you're confused yourself.
Roger.
Ah, yes.
Madam, this model was submitted on 7/5/2025, then we are going to submit the traversal report by 10.
Then you submit it on 12, doesn't
Yes,
matter.
madam. Without considering that, madam, base representation, they have issued the improved notice for the 8/5/2025,
Page?
page 56. Page 55 is the, madam, our representation dated 7/5/25, is the action plan as well as the date of submission of the traversal. We said we are starting the work from the last part of the, May 2025. Okay. So,
As per your work action plan, when are you supposed to start your work?
But it starts after the submission of the traversal report.
So, traversing report was submitted on 12/5.
On 12.
So when are you supposed to start as per your traversing report?
But, from the last part of the this last week of the May 25.
Last week of May 25.
Next week, madam, last part.
When? I said when? Which date?
But the date we said like.
Well, let us see your traversing report.
May I submit one thing, my lord? In this regard, in panel number 25, my lord, an arbitration proceeding is going on in this case, my lord. That is, my lord, last date was on, that is on 11th, my lord. 11th.
Arbitration case number?
Arbitration case number,
that is
I'm
with
giving
regard
on.
to some pending bills.
yes, pending bills, in panel number 25.
That is with regard to some pending bills that are.
May I, Honorable Court, may give some time, I'll produce all these documents which is in that case, my lord, arbitration procedure.
Madam, what he's talking about. Madam, look this side, look this side.
Yes, my lord.
There it has to be a true two-way traffic.
Yes,
You see, the thing is that what he's talking about is that he is now agreed with the order at page 56.
Hmm.
This is the notice served upon him. Okay,
yes, my lord.
where there has been a threat that the contract will be terminated under clause 62.
62, that is for default of the contractor.
Clause 62.
Yes.
Now, that is not under arbitration. What is under arbitration is his pending bids. Correct?
Yes, ma'am.
So how do you connect the two dots?
No, may allow some time, but may I go through it, because I'm the counsel in arbitration proceeding also in the panel number 25 of my this one. So may I go through it, madam? Sometime, ma'am.
No problem.
My
Sometime-
criteria would be, my lord, to consider my representation dated 7/5/2025, which was submitted one day prior to the, my lord, 8/5/25.
And sometime, maybe-
And
No, this is a notice of 8/5/25. Why
Yes.
didn't you submit a reply to this notice?
no, but we have submitted it.
Where is that?
Yes, madam. Page 57, madam.
Reply dated?
Reply dated 9/5/25.
So let them take a decision on this.
In the, but this 8.5 should not be acted upon.
Huh?
Because in that 8.5 should not be.
Naturally, they will not.
Yes.
No, I mean.
Because they said 7 days, I have to show them the work progress, otherwise they'll invoke clause 62. So from 8.5, this 7 days expires in 13.
Let us see a traversing report. Let us see a traversing report.
At page 63.
Yes,
This is basically data, my lord. In
yes,
continuation.
where does it show that you're going to start your work?
So this is a different part, my lord. I have to survey all the different angles and take a measurement.
Mr. Council, I had asked you, when were you going to start your work as per your, start your work? You said that it is in the traversing report.
No, not.
And then you also
I'm sorry,
said,
I'm
you
sorry,
also
I'm sorry.
said that it would be in the end of this month, May.
But that is in 7/5/2025. That action plan also. With the commitment that I'll be submitting the traversal report on 10th of May. And I'll start
Which-
work from the last week of.
Where have you said that?
In page 55, Lord Chief Messenger, and also page 56, so this is page 55. Mary,
Where is your work action plan? Your work plan?
yes, madam, this is, here I'm mentioning, madam.
This cannot be a work action plan.
This is the way it will be given, madam. The way.
Page 55.
Gotcha. Clause 1, closed traversing survey has been completed by an agency, namely Horizon Private Limited, and their report submission expected on or before 10 May 2025. We have remobilized manpower partly to the site and remaining manpower to be positioned for taking up balance work by 2025. All the equipment and machinery which remain idle since 2022 on account of stock.
Last week of May 2020.
That's all. Village authority maintain and put in work condition as expected to completed by 2025. Material procurement change for balance lining work is also being finalized with various agencies, and the same would be completed by 2025. With the completion of all above resource convention, we are intending to recommence the work in the last week of May 2025. In the meantime, kindly release pending payment so. So this is what we have given details.
And can you
Oh,
take
without-
the matter after half an hour? Because last thing on 11th of May, I was there. On that day, they themselves told before the arbitration that they did not start that traversing work. So I'll take instruction half an hour, maybe given by law. Half an hour, after 11:30, I'll come with that all.
I'm being notified.
This of the case. The railways have floated a tender. It's a service related tender, cleaning contract.
That's it. Yes,
It's a cleaning contract, period is for 48 months. But you will get the details at page 27. But you will go to page 35, there all the details are there. Page 35. Challenges in a very limited compass. The name of the work is cleaning of coaches of so and so. The approximate cost as per the tender is around 39 crores, and the period is 4 years. Now, they have evaluated the tender. I am the L3 bidder. He is L1,
petitioner is L3,
petitioner is L3,
this phone number.
4 is L1, and R5 is L2. R5 is not appeared.
Maybe. So the contract has been awarded to R4.
R-
And even if you succeed, it will be given to R5.
R4 and R5 do not meet the minimum wages criteria. That is my case.
Okay.
Now, my lord, on 18/2, I filed a representation,
18 to what?
18/2 of 25.
When was the contract awarded?
Contract was awarded on 18/2.
Okay. Where is your representation page?
At page 154.
Yes.
My case is, my lord, that if you take the minimum wages, PF, ESI, everything, then the minimum value of wages comes to around 36 crores. At page 155, my lord. Lordship sees that table,
Yes.
36 crores, 18,72,441. And both R4 and R5 have quoted below this level. That is my,
And how much have you quoted
I
beyond this?
I have quoted above this one,
Above.
above.
So according to you, the rates given by them were not feasible. Why?
Yes, because it does not comply with the Minimum Wages Act, Provident Fund Act, and the Employee State Insurance Act.
Minimum Wages Act and
The Employees Provident Fund Act, the name is long, but Employees Provident Fund and Miscellaneous Provisions Act.
third,
The Employees State Insurance Act, 1948.
and
These are the Minimum Wages Act. and the- Provident Fund and ESI Act. Now, madam, they replied to my representation at 157, page 157, saying that giving the detailed calculations
reply by whom?
by the railways.
Yes.
Now, there they have given the calculation on which they have proceeded. And on the face of it is erroneous.
I don't know. For me,
Yes.
everything looks
Yes. So now the
okay.
the calculation they have made is that whatever is the monthly wages, to arrive at the daily wages, they have divided the sum by 30. Now, this is contrary to the minimum wages rules as well as the ESI Act, rules one. Now, before taking your lordships to the the minimum wages rules, my lord, since the ESI central rules is part of the writ petition itself, my lord, at page 163.
What page?
Page 163. The ESI rules, my lord, define the term average daily wages.
Yes.
May I just read, my lord? Section rule 2, 1 capital A, average daily wages during a contribution period in respect of an employee. Or should we take up the rules also? One A,
Average daily wages.
average daily, 1B, madam. Average daily wages during a wage period means in respect of an employee who is employed on time rate basis, the amount of wage which would have been payable to him for the complete wage year period, had he worked on all the working days in that wage period, divided by 26 if he is monthly rated, 13 if he is fortnightly rated, and 6 if he is weekly rated, and 1 if he is daily rated. So if he is a monthly rated employee, my lord, his daily wage will be arrived at by dividing it by 26, not by 30. Why, my lord? Suppose a workman receives 26,000 money. Just for example, if we divide it by 26, his daily wage comes to 1,000. But if we divide it by 30, my lord, it becomes less than 1,000. So 26, why 26 has been taken, my lord? It is more beneficial. So the question comes, my lord, what happens to the rest days? 4 days, rest days. Because under the minimum wages act, my lord, I am required, employer is required to give a minimum of 4 days of rest. I cannot make the workman work for 30 days in a month. So the daily wage which is fixed by the authority, my lord, it includes those days, wages for those days. That will be clear, my lord, from a reading of the minimum wages rules, man. Rule 23, sub-rule 4, the proviso thereof of the minimum wages central rules.
So what is the wages being given to you in a month?
Now here, my lord, the minimum wages is fixed under the minimum wage of on a daily basis.
On a daily basis?
On a daily basis.
So,
So the calculation which they have made is by dividing it by 30. As a result of which, my lord,
no, if it's a daily basis, where's the question of division? Then it will become less. Where's the question? If it's on a daily basis, why should it be divided?
no,
It's already there.
The calculations which they have made for the contribution of PF and ESI, they have divided it by 30 months.
You mean to say they've added it up and then
They
divided
have
by
added
30?
up. They have taken the monthly wages, added up the monthly wages, divided it by 30 to arrive at the daily wage.
But if the rate is fixed on a daily basis, and that means when they're adding it up, they have added it up or multiplied by 30, then what's wrong? If it is multiplied by
It's
30,
not multiplied by 30 months. What they have done, that the PF contribution, there is a maximum fixed.
no, let us take one example. Now, what is the daily wages of say a particular employee, say petitioner? Petitioner, no,
655 month
655 per day,
per day.
655 per day. That is only the wages.
That is only the wages.
That's only the wages.
That is only the wages. On top of that, my lord, 13% is the PF
Yes.
and 3.25% is the ESI contribution.
So, so per day, it will be 655 plus 13% plus 3.2%, is it?
Yes, but there is a catch, my lord. The
No,
moment-
just a minute. So how much does it come to per day?
no, madam,
After adding 13%
it
and
will- it will not-
3.2?
it will not be like that, madam. The wage ceiling so far as PF is concerned is 15,000. So the PF
Wage ceiling?
So anyone who is getting above 15,000, madam, the provident fund will not be deducted for the entire amount. Provident fund will be deducted only for the 15,000. So the amount of provident fund for an employee who is getting more than 15,000 a month is the same. So there is a difference in that. So directly, if we calculate in that manner, my lord, Lordship will not get the figure.
Anyway, you see this, so basically he's getting 655 a month, a day. So to get his monthly rate, you'd have to multiply by 30.
My lord, may I? No.
Yes,
26?
why not? Why
26?
26?
That is the catch, madam. Because he will not work for 30 days. He will work for
Maybe,
26 days.
but he's going
Exactly,
to,
my lord, exactly.
he's going to be given for
No,
the
my lord.
30 days.
No, that is the catch, my lord. And Lordship will kindly take up the minimum wage there. The rules. The reading of the proviso will clear everything.
Doesn't seem to be clearing anything.
Lordship will kindly read the rules. 23, sub rule 4,
Of the,
minimum wages rules, central rules.
yeah,
Rule 23, sub rule 4, madam. Because 23 pertains to the weekly day of rest. 23, 4, madam. An employee shall be granted for rest day wages calculated at the rate applicable to the next preceding day. And in case he works on the rest day and has been given a substituted rest day, he shall be paid wages for the rest day on which he worked at the overtime rate and wages for the substituted rest day at the rate applicable to the next preceding day. Proviso is important. Provided that where the minimum daily rate of wage of the employee as notified under the Act has been worked out by dividing the minimum monthly rate of wages by 26, or where the actual daily rate of wages for the employee has been worked out by dividing the monthly rate of wages by 26, and such actual daily rates of wages is not less than the notified minimum daily wage or daily rate of wages of the employee, no wages for the rest day shall be payable. So when we divide the monthly wages by 26 and the figure arrived
but
at is the
Mr.
minimum
Counsel,
wages.
your argument is on the basis that there is a monthly wages, 6 monthly. But you have said at the very beginning that the wages are fixed on a daily basis. So where's the question of monthly wages?
Because the entire calculation made by the railways is on monthly basis, my lordship will kindly come to page 157.
No, you see, when the daily wages is at the rate of 655. Now, 655 daily wages, he has to be given for the entire month,
For 26 days.
for 26 days, even if there is 3-4 holidays. So you multiply it by 655, that's all.
No, my lord. Lordship will kindly bear with me, lordship will kindly come to page 157 for a month
157
of
of,
the rate.
where?
Lordship is. The total liability of the contractor, my lord, what it comes to. We are taking only the unskilled part, my lord. The daily wage is 655. Lordship sees.
Yes,
The employee's contribution or under EPF Act is 12% on the wage ceiling of 15,000. Now 15,000, they have taken it at daily basis of 60, cannot be, madam. 15,000 is not the wage for 30 days, madam. 15,000 is the wage for 26 days. So that comes to not 60, it should be 65, madam, not 60. When the employee is paid for the entire month, this will not make a difference. But if he works for 10 days, my lord, there will be a difference of 100 rupees in the, so far as the PF contribution is concerned.
so you mean to say this employee's contribution
Yes.
of 60 rupees is not the correct thing?
Not the correct thing. My calculation is at page 161, madam.
No. So they have taken it at the rate of what, 60, at the rate of?
15,000 for 30 days, madam. Because the 15,000 is the upper ceiling. The 15,000 is for 26 days, madam, not 30 days. When you are calculating the monthly wages by multiplying it by 26, the daily wages, the upper ceiling cannot be divided by 30, madam. It has to be by 26. In a month, if he is getting, because I have explained in my reply affidavit, madam, it makes no difference if he is getting the, crossing the 15,000 ceiling. Now, those 4 days, madam, Lordship will kindly consider, those 4 days, I will have employees because I'll have to manage the show for the entire 30 days. I cannot make a particular employee work for 30 days. So there will be a substitute employee who will not work for 30 days, who will work for a period less than 30 days.
But that is not our issue. That is not the issue whether you hire somebody else or something.
I may hire, and if the calculation is wrong, madam, ultimately the sufferer will be the laborers, madam. Because what I am on, my lord, the railways in their own, in another contract have made the correct calculation.
So this 15,000 will have to be divided by 26.
26. Why I am saying, my lord, if your lordship kindly comes to page 165, this is in another contract. I show the flow, my lord, from this
So
reading of one
it's only with respect to the
provident fund as well as
EPF.
ESI.
Huh?
Provident fund as well as ESI, the difference comes to around 10 rupees per
And
day.
why under the ESI, there is a ceiling of 15,000 also.
No, see, that's 21,000.
Yes.
Same thing will come, my lord. In fact, in the case of
No,
ESI,
but out here, why is there at column, called a serial number 3?
my lord,
What is this employees, other charges?
this is included. I had said 13%, right, my lord?
Under the seven, my
So
lord.
under the
Ah.
PF,
Under the APF Act, but there is a provision for 0.1%.
under the PF Act, my lord, there are two portions.
Dealing
12%.
insurance, my lord.
12% is the direct calculation. This is EDLI. This is some insurance, my lord.
Dealing.
Linked insurance. So ultimately 12 plus 1, it comes to 13%. Both on 15,000. 0.5 and 1%.
And 4? 4 is
4
the.
is the ESI.
Hmm.
Now lordship comes to the figure at serial number 5, column 5.
Yeah,
This is what they are saying, the total cost of staff per day.
where? Volume
At 5,
5 or
madam.
serial number 5?
5, madam.
Yeah.
Total cost of staff per day. That is will be 738. Now lordship comes to 7. Cost per month is 26 days. They themselves calculate, my lord. While arriving at the daily calculate, they divide by 30. But while calculating the monthly, they multiply it by 26. madam. Am I clear, madam?
Not exactly.
5 is the
So
total
this,
cost per day.
this 7 should be also multiplied by 30.
If that is so, it should be that, madam. In the same document, while arriving at the daily wages, you are dividing the monthly wages by 30. But while arriving at the monthly wages, you are multiplying the daily wages by 26, madam. That itself is a fallacy. Now, my lord, if we multiply 738 by 26, going by their own calculation, the amount comes to 19,199, my lord. You will kindly make a note. It is 19,199.7. And lordship turns to page 165. Lordship will kindly have both pages at the same time. Now, in page 157, lordship has noted the daily wage is 655, madam.
Yes.
Yes, madam. Now, lordship comes to 165. The daily wage is 651 at the very beginning.
Yes.
Now, daily wage is 651, and lordship comes to the third last, Roman 11.
Yes.
This is the contractor's liabilities for 19,426. My lordship will make a query to the railways, madam. When the unskilled daily wage is 651, the monthly amount comes to 19,426. But when it is 655, how does it come to 19,199, madam? 300 rupees less. When the daily wages is more by 5 rupees. This mistake, my lord, I have got a tender of the railways, my lord. I could not bring it by way of an additional affidavit. There also, my lord, it's a tender issued by the NF Railway. There also, they have taken it as 26, my lord. And this document at page 165, the railways in their affidavit do not deny.
Where is the railway?
It was not 20, my lord. Now it's
Huh?
5, my lord. But there is no quarrel with regard to daily wages, madam. And I average wage, madam, daily wages. It's been with regard to, my lord, for how many days, my lord, the contribution is to be paid, my lord. It is for 26 days or for a month, my lord.
What is to be paid?
The contribution has to be paid for the entire month, my lord, yeah.
Okay.
Not for the 26 days, my lord. Who will give the, my lord, the 4 days, my lord?
No, what do you mean?
My lord,
Oh,
the
yeah,
contribution-
yeah.
But as per the act, my lord. the
Which act? Which act?
ESI and Provident Fund.
Madam,
they contribute-
before my learned friend starts, Lordship will bear with me. If your Lordship permits, I want to place a copy of the tender of the NFL.
No, before that, I want to know where the railways are. There is no point hearing you two and without listening to the main actor.
Common council is here. SS Ray is appearing. SS Roy is appearing.
You two are the bad guys. I need Dharmendra Raman to be the main person. He's going to explain everything.
Because he'll be relying on the 18-2 document, madam. As well as the,
Yes, can I decide this matter without hearing the
No,
railways?
no. Definitely not.
Then the problem, see, I don't want to go further. For the simple reason that I hear both of you at some length and they don't turn up, then
The Lordship will have it day after tomorrow, madam.
no.
Because Lordship is rising at 1 o'clock.
I have to. My trial before that, 12:30. Because I've got to head the tribunal. And I've got to pass my order in the tribunal within this week,
Under the European.
within 6 months. Came to me late also, came to me after, I think, 2 months, after 2 months it came to me. But 2 months lost. And by the time issuance of notice and everything. This many evidence.
My case, my lord, is that
Okay, a simple query, Mr. Patel. Wages 655,
Yes, ma'am. Multiply by 26.
multiply by 26.
26.
Well,
About for 26 days, my lord, it calculates 650.
no, but then out here,
I get an issue is, my lord.
no, listen. 655, but they're supposed to get paid also for the holidays,
Holiday.
for the 4 days, Wednesday. Now, 655, the minimum wages notification
Yes, is there.
is per day, it's
Per
not a monthly wage. So that means 655,
Which
Yes.
includes, my lord, for the whole month, my lord.
no,
Six.
how can it be?
No,
How
six-
can it?
no,
No.
6 into 26.
Let us see the, no, yeah, the basic.
No,
is
but
wrong.
this 6 by include,
No, then.
but 20. But as per act, it has to be, my lord, multiplied by 26. My
No, it's like this, Mr. Council, supposing the government says he's supposed to get daily wages of say 100 rupees per day,
Yes, my lord.
and for the 4 days holiday, he's also supposed to get another 100 rupees each. Then what happens is that if the government says per day the rate is minimum wage is 100 rupees,
Yes.
that means in a month it will be how much? Into 26, how can it be?
And as per act, it multiplied by 26, my lord.
Common sense, Mr. Council.
Yes, I know, my lord. But as per act, 26, my lord. But. here I-
No, let us see as per which act.
Yes, sir.
Let us see which act.
And the minimum wage rate, my lord.
Yes.
Rule 23, my lord. Sub rule 4, provision, my lord.
23. Yes,
Provided that the way minimum daily rate of wages of the employee as notified under the act has been worked.
Rule 23,
Yes.
section what?
Yes, that be provision, my lord. Rule
No,
20
which rule?
Right.
Rule 23,
Rule 23.
the first proviso
Yes, madam.
or second proviso.
First provision, madam.
Yes,
Provided,
provided an employer has worked in the scheduled employment schedule for a continuous period of not less than 6 days.
broken by dividing minimum monthly rate of wages by 26.
Where are you reading?
Madam,
Which rule?
madam, proviso of my rule 23 clause 4, madam.
23.
My start with madam provided.
Okay, wait, sub rule, you mean sub rule 4.
Yes, madam.
Provided that there is a minimum daily wage Oh, rate of the employee minimum. You see, this is where it has been worked out.
Yes, madam.
Let us see the notification.
Yes. Madam. No, it is in the affidavit, madam.
Page 201.
Yes. In exercise the
Second
powers
column, madam,
conferred by.
the unskilled, madam, the B area,
No, no, and, revise the average.
in second row, madam, the unskilled,
No, no, I'm not on that. I want to see the basis. So what do you mean to say that these rates that are fixed,
yes,
this is a 260, this one,
301, madam, it's the second row,
B,
madam, B,
655.
yes, madam, the B area,
So you said that this has been a worked out rate.
yes.
This rate has been worked out.
So, madam, what is the, madam,
It is not a rate fixed per se, implicit.
yes, madam,
It is a worked out rate
work out,
by applying this 2023
yes.
section rule 23,
Rule
is it? So this is the worked out rate. So that is the basic
Yes,
issue.
madam, now, madam, what
So
is
the
the,
basic issue is this. According to you, this is the worked out rate.
yes,
And according to him, it is not the worked out rate. It is the rate simpliciter
yes, madam.
fixed per day. That's what he said.
Now, madam, what is the
Now
contributing?
that is
Now,
the
madam, what is the dividing factor for coming to a conclusion about the contributing, madam, the PF contribution for whether it's a for month or whether it's for 26 days, madam. That is the issue, madam. Will I,
anyway. One thing. What to do? Railways is not here. Ajay, you're also railways, correct? No, I know, but you're against railway also. Then, what to do?
Someone else is representing. the railway
Maybe,
sector.
but there's no railways here.
Yes.
That is what I'm saying.
X says, madam, the EPF and ESI contribution should be paid for the whole month, madam, not for 26 days, madam.
Okay,
That is the issue, madam.
okay. The ESI and the
EPF,
EPF says that it should be paid for the whole month.
whole month, madam, not for the 26 days, madam. If you go by the, madam, so rule 50 of the ESI, madam, this talks about for a month, madam. The EPF also for a month, madam, not for 26 days, madam. So necessarily dividing.
But it has to be calculated on the basis of the daily wages.
Yes, madam. That's why, madam. The EPF, madam, would be, madam, the 12% into, madam, 655 into 26 or, madam, the minimum selling limit, madam. That is 15,000, madam. That is come to, madam, 1,800, madam.
So anyway, both of you, this wages 655,
There's
does
no
it,
point, madam.
does it cross the 15,000? It doesn't.
It
Yes,
does.
Huh?
It does. It does
It
cross
does.
the 15,000.
That's why, madam, it's, it had to be taken by 15,000 is the West ceiling limit, madam. So for calculation of, madam, the EPF contribution, sir. The 12% into 15,000,
So 15,000 has to be anyway, that's the minimum. So,
that is 1,800, madam.
so you've got to pay
Now,
on
madam,
the,
what?
on the 15,000,
Yes, madam.
the 13%, no?
30%.
13%. So that is not a
That
problem.
is the issue.
That is the issue.
Now, how?
That
What
is
is the
the issue.
dividing factor? It is 30 or 26, madam. X is, madam, for a month, madam.
May
So
I,
if you calculate for 1 day, madam, it's come to 65, madam.
may I? Conduct?
Rule 50 is clear, madam.
Since the wages are on per day basis, the PF and ESI contribution will be also be calculated on per day basis, madam. It will be paid for a month, that is a different issue, my lord. But it will have to be calculated on per day basis. So when 655 is the daily wages, that will not come for the purpose of calculation of PF because it exceeds the calculation of ceiling of 15,000. So for calculating the PF for per day, if 15,000 is taken as the salary for the month, whether it will be divided by 30 days or 26 days, my lord, Prakshak will have to answer that simple question, my lord.
Has it never been answered?
Answered, madam.
Well,
In the affidavit, madam, of the railway, madam. I'm relying the affidavit, madam.
I talk about some other courts.
Let me have my, because
Other courts like Supreme Court, like the other high courts.
But I don't find, madam.
we have not found, my lord. Because the law is clear, madam. 26, even the ESI.
The problem is both of you are clear. Both of you are very, very clear. I am the one who's not clear. And especially without the help
if you
of
go
the
by this
railway, it
EPF
is very
back,
difficult.
It will go by the EPF back, it is clear.
No, no, but
It is for a month, my
let,
lord.
let us wait for the railways. How can I decide this matter? I am hearing both of you only. What to do? List it again. List it again, no problem.
Only I pray for an early date, my lord, because the work is progressing.
Next week.
Next.
Then I
Madam,
want-
it's not there, madam.
Some other will do it. How does it matter? On the fair of the parties, this is the matter. It is right. In view of the absence of the council for the railways, this is the matter the next.
On fifth. Fifth, no. On 29th. On 29th.
Okay.
29th. Then we have 6.
As per the order dated 8/55, the chief party order, the chief me to file a petition affidavit that I have filed with the that flag P laws. That they have opened the financial people. Five.
Yes, who is going to start? He has not come.
No, I haven't come. So that lordship in the flag P lordship has given page 148 and excess 17.
Page 148.
Page 140. 148. This yes, that the two-person, the Ranjit Puro. Is the Ranjit Puro and here, who has opened lordship can see they have given it. Lordship, these banks lordship on the record. Here lordship, these persons are there on the financial bid opening date lawsuit on 20/2/2024 lawsuit. These banks lawsuit on the record lawsuit. All the minutes lawsuit. I provided to the course of something. There is one bank, of 3 minutes of 3 centers. Last year lawsuit was second. Minus, all minus, Costco minus. Because this was produced in pursuance of the order dated 9/4/25.
Yes,
So here Lordship can see the at page 12, Lordship,
page 2.
page 12. Page, it started at page 11, Lordship. Lordship was saying. Page 11. Of that file.
Yeah,
This is the minutes of the tender financial bid of the offering held on 22/2024 at 2 p.m. Where they have taken this decision, since there are only 2 bidders participating in the process, to have a better participation in the numbers of the bidders to ensure the quantity of the committee member would like to recommend the principal township superintendent of the and the superintendent will say the bidder to float the first tender through same company. Now, this person is signed. All this, out of this, Lordship, 2 person is Hitendra Sonowal and Partha Sarathi Borwa. Lordship, that's this. And third is Somendra Kumar Bhagavati. These 3 persons, this Bhagavati and Sonowal, they have opened the tender. This 140, page 140.
which Sonowal? Ramesh Sonowal or Hitendra Sonowal?
Hitendra Sonowal. Hitendra Sonowal is in the first column, second name, Lordship. And the S.K. Bhagavati is in the third column, Lordship, top. Both of them are there. So this is regarding the opening of the tender. Now, Lordship, that there is a rule, all these guidelines, the 164, Lordship, I have annexed, is 164. We started, then 166, Lordship may directly come. 166. Page 166.
Yes,
It is in the top, Lordship, procedure for financial opening and financial valuation. Procedure.
yes,
Lordship, in the 2 financial opening, there are bullet point, Lordship. It is the third from the bottom, bullet point. As the financial document can be downloaded after at least 2 successful decryption. Therefore, 1 more bid opener should be declared the bid by using the same procedure. After successful decryption by the 2 bid opener, a folder appear automatically. Click on the folder. Then click bid document G to download all the financial document in this information. So this is Lordship, the 2% click then upload. Minimum. So it is the Lordship, the 148, 149, it is the handbook on the Assam State e-procurement portal. Page 149. This is the whole document, Lordship. Page 149, Annexure 18. It is prepared by the procurement team, Finance Department, Government of Assam. Page 149, Annexure 18.
yes,
It is the handbook of Assam State e-procurement portal. Here also prepared by e-procurement team, Finance Department, Government of Assam. So this page 166.
This particular point is concerned, madam, they want to establish that, madam, financial bid was open. I have got the instruction, it was open. But it was never uploaded. And it's not, we are not binding that we'll have to upload it because we have cancelled the tender. For this part, madam, I will place the instruction, even whatever rate the petitioner has quoted and other bidder, I have got the instruction, I place. I will serve a copy to them. So this point is not clear. So point of asking, because I have got the instruction.
Together we do not talk, of course, so we have to bring it like that. No, because the, to my information, Lordship, I am the lowest bidder.
because it was not uploaded, rats were not uploaded. To my information, because there are so many members, they said that the body was to the opening. I will check. This one. Now, Lordship, this now we have bring it to the notice of the court by filing an affidavit, but Lordship can see is 97 is the affidavit filed by the government. Is 97.
Yes.
Case 97 is an affidavit in opposition filed for and on behalf of the respondent number 4. The principal comes if superintendent of Assam Medical College. So he on behalf of all. And he has said that he has been authorized by all to file this affidavit. No way. Lawsuit. This is mentioned. That they have opened our hands. They said only that.
That is a different aspect of the matter. The main issue, I think, is whether PM portal can be done or not. That's all. Let us not go into the side issue.
Then for that lawsuit, I'll go to the act lawsuit, that's true. But in my point is lawsuit, on the date of the filing of the affidavit, we do not know lawsuit. When we heard about it, we have filed a reply.
No, that, okay, that, yeah, that can be made out, that, okay, you did not know. It's all right. But then no point dwelling on it too long, we are wasting time. Let us go to the main issue.
Then because why I have said that there is no reason, nothing. Suddenly they come to India when they have seen that the iron below. Then they have taken the decision, that is why. So that. Now lordship to that be a substantiative thing, lordship may have to take the act. Lordship, please come to section 26.
Right?
Lordship at Lordship at page 20. Page 20, section 26. Cancellation of procurement process. A procuring entity may, for the reason to be recorded in writing, cancel the process of procurement initiated by it at any time prior to the acceptance to successful bid, after the successful all bid. 2, the procuring entity shall not open any bid or proposal after taking a decision to cancel the procurement and shall return such unopened bid to the proposal. This they have not done. They took the decision, then they have opened my financial. And they have not returned. This 2 is not, this is totally a violation law. Then 3. The decision of procuring entity to cancel the procurement and reason for such decision shall be immediately communicated to the bidders that participated in the procurement process. Not done also. On oath, I have said I do not know anything. I go to the office many a time. Nobody has informed me, nothing. And in the affidavit, they have not said anything to this regard. That they have done this. So this is regarding the cancellation of procurement process to go for a jam. Now 28 is the method of procurement. There are many other methods. So these are the procurement process.
No, no.
Let's see, in a hurry, I can do any, there's no, I think both of us can fix a date. It's not that much. It's not that much. Any date, so I don't want to.
Private letter.
Huh?
Today Lordship has got a private letter. Okay.
After that.
Let me, at least you can complete this part. So only my submission will be only to defend that the decision of the financial peak committee of 20th of February. Why we have cancelled? Because this part they are relying upon this part. Main issue is that.
That's the main.
There is a decision by the Lordship will have to do.
The Lordship will come to section 20.
Yes.
Every procuring entity shall prefer the open competitive bidding as the most preferred method of procurement follows. Open the competitive bidding may also be followed in case of two-stage bidding. In our case, lawsuit is two-stage bidding. Technical and financial. In terms of the section 32, electronic reverse auction in terms of section 33 and red contract in terms of 36. So this is very specific lawsuit. Our red contract, we have given 2 weeks, it is there. Technical and financial. Then 4, where the procuring entity chooses the method of procurement other than the openly competitive bidding, it shall record the reason and circumstances thereof. And lordship will remember, this is the 4th time. It is not that lawsuit. There are some decision lawsuits that they would cancel one tender and they will go to them. It is not that. It is the 4th time lawsuit they have cancelled. Every time they have given first one, 2, then 4. All this 3rd time. So lordship, please come to page 27. Page 27, section 36.
Yes.
So this section 36, one is, lordship will get the section 29. The one is not there, section 2, 36(2) is there. This is what we do. Yeah. Because 29(2) is the red contract, lordship, I have read that. Now lordship, this 36(2) is the ZAM. So it is not part of that section 29, open competitive bidding. This is government e-market. And lordship, here lordship the 2, lordship will come to the next page, or I can read the whole thing. Director General of Supply and Disposal host an online government e-market place on pilot basis, for common use goods and service. The electronic and online procurement process on ZAM is end-to-end from placement of supply order to payment to the supplier. B, government procuring entities, including the state government entity, at their option, view, compare and directly purchase online the product and service offered by the various suppliers on ZAM under such condition as may be prescribed by law. So there is a distinction. So they have, initially they have gone for the, all these tenders. For a moment, lordship, let us see the affidavit. Page 101. What they have said in the affidavit, why? Lordship has noted that in the last order. Page 101. There are none. That with regard to the statement made in paragraph 14 of the petition, important to deny the government medical exception. On the other way to submit, that no illegal and arbitrary manner has been acted upon as per the government notification number so and so dated January 2024, January mandate. Page 101. Their affidavit in opposition. Only stand of the government. Page 101, paragraph 9. That with regard to the statement made in paragraph 14 of the respondent state, a government made it to the petitioner on the further way to submit that no illegal and arbitrary manner has been acted upon as per the government notification here is number 22 dated May, January 2024, then is mandated. As such, a trace tender was invited to government. So now, lawsuit in the paragraph 9, they say it's a notification. Though it is not a notification lawsuit, they have annexed that, it's an office memorandum. It is not a notification. Now lawsuit, there is a definition of notification under this act. And lawsuit will put that question directly to the government council on that day. At page 5. At page 5 of the act laws.
No, just Mr. Gogoi. You have also still issued some tenders in a normal process.
Yes.
Many laws.
Lordship will see, my lord, page 105, just one word I will point out, my lord. Page 105 of the OM, my lord, of the government, page 124. Points.
105.
105.
Yes.
A, my lord,
Yes.
for procurement of goods and services, one, government, that is JAM. JAM is mandatory for all procuring entities for procuring of all goods and services that are available in JAM. Those are not available in JAM. Because it is to be registered, my lord. We'll have to see, my lord, whether the product that we want to procure is there in JAM or not. It will have to be a registered product in JAM. Because, my lord, other cases, lordship has, my lord, dealt with, my lord, regarding PWD, where we have found that, my lord, there are certain products are to be, my lord, before and it will have to be registered. And there are product specific terms and conditions, my lord, for every product. So here, my lord, so far as those are concerned, my lord, those are, my lord, various medicine and others, my lord, which are not there in the JAM portal. So we have to, my lord, resort to this.
My lord, we have specifically filed that affidavit, there is no reply now. They have not denied. I got on record all this, there is no denial, nothing. And there is no reason that it is registered or not registered, this is not registered, and nothing, nothing. Now, lordship, there is a pertinent question, lordship has asked the government. Lordship, please come to page 5 of the act. If that is how lordship is page 105, they can do already.
Page 5 of the act.
Page 5 of the act, Lord, this act. Lordship has asked that question that way, there is no answer.
Yes.
Q.
Yes.
Notification means notification public in the official gazette. This is not a gazette notification, my lord. There is nothing, it is not gazetted. It is specified in the act.
It is the office memorandum, my lord, from the very language, it is,
Oh,
lordship will see
then
the
lordship,
heading.
I'm
No
sorry,
point.
then it is in the affidavit.
Oh, that's a different
It is
issue.
the
Some
government-
wrong wording
government
will not
is
change the
very specific.
notification.
Government is very specific in paragraph 9 law.
Not by government. Lordship will see, my lord, office memorandum, it has been mentioned in page 105. Why making a word, my lord, the notification? Because if it is a notification, it will mention the notification instead of office memorandum. I will reply to that.
So there is
I will
no
reply to
notification now. So there is no notification. Unless there is no notification.
Not enough.
There is no notification. This is office memo. What they cannot do. They have to notify us.
How much time are you going to take?
So I have to pay this act and do.
How much time?
45 minutes.
Okay.
Not 45, half an hour.
No time, no time. I have to pay.
And judgments, I have to place the judgment of the court.
Ah, 250.
Just 1 hour.
My 1 hour.
Because I have to place my judgment also. Judgment, sir. On the direct one.
Then we'll take it up after something. Let's change the matter.
Anytime can be.
That'll take too much time, no time. Trust me. Like, on the paper agenda, main. This is the matter. When do you want?
My lord, if possible on Thursday itself, my lord. Then, my lord, on.
No, 1 hour I can't.
29th,
On 29th. This is the matter.
29th.
Not 29, 30th loss.
30th.
The 30th is the Friday,
I
lordship.
have a matter with them.
That is miscellaneous day, lordship.
4 days.
27.
27.
27.
27.
27.
27. I'm being understand. I'm getting to work.
And the present status of that notice, my lord. 148 hours notice has been given on 19/5, my lord. And second.
So 19 years, 19. Five, 2025. Page 54.
Yes,
Last paragraph.
yes.
Therefore, we are to immediately review the work as well as submission of the post policy that are final 25. Kind of thinking for commencement of the remaining work at the earliest to avoid further inconvenience. Please note that later with the applicant to issue a 7 days notice and subsequent follow-up action accordingly. If work will not commence from this technical discipline. Now, this immediately thereafter, on 7, you have submitted for that case will be my contribution. Number one, those traverses survey have been completed by an agency so and so, and their reports are expected on or before May 10, 2025. We have demobilized manpower partly to site and remaining manpower to position for taking a talent for 5/25/2025. All the equipment and main items is off-site because work of the office of the Makuma village authority are being maintained and work condition completed by 2025. Material procurement chain for balance time work is also being finalized with various agencies at the same completed by 2025. With the completion of all above the resource remobilization, we are intending to recommend the work, recommend the work the last week of May 2025. Pending payment by April 2012, GST balance of that amount will be approval of variation under an effort which is to be done. This something including of balance of 1. Then, my lord, without considering this, one of the state things, the people are an issue. Last paragraph, my lord. As we have to abide by the inspection should be for progress of the work, you are hereby given 7 notice in accordance with clause 60 of the General Construction this project, stating which other action has provided in clause 60 of the General Condition of Contract. Terminate your contract and complete the work activities can first be taken. Against that, the next day, 9/5 and 6/7. we have submitted.
So what is your prayer right now?
Let them, let them, consider my this representation 7/5/2025 as well as this 9/5/2025. Take a decision.
9/5/25, that is at page 57
57
and,
and 7/5.
and 75.
At page
55 and 57.
And also we have submitted the post emergency report on 12. That is at page 63.
But you all are very smart, you all are not, you're, in your work plan is 55. Is the work plan page 55?
We have submitted.
No, I'm not, initial work plan is not workable,
No,
that's finished.
No, that has been submitted 27/1/25. Page 50. Detail. Yeah, certain conditions are set.
No, but now you have issued a fresh work plan on
These are we are
7/5.
we are commitment that by this time we have been in the different stages of people.
Yes, Miss Madam.
Kindly the status of the work, that is second phase of, that is 48 hours. Second phase of this paper. Just I have given.
Second page,
Yes, ma'am.
yes.
In reference to this officer, the above render unders inspected the work site at tunnel T25 as on date 18/5/2025 and status you have submitted the details of action initiated from the agency ECI for the work tunnel T25 third year letter of reference which are being closely monitored from the railway end and found the following work at site. Proper close traversing survey report having any correlation of approach alignment of the tunnel T25 as well as alignment of the bill alignment of tunnel T25 is not submitted. Then-
According to them, they have submitted.
But that is not proper, my lord, that the approved alignment of tunnel T25, my lord.
Okay, that's not proper.
It's not in, my lord.
But they have submitted,
There's submitted, not that,
but not a proper alignment.
not proper alignment. Because there is a misalignment was there, my lord, in that work. That is, for that, they did not submit any project.
Okay, so they submitted a closed traversing survey report, but it was not on the proper alignment.
Not all proper alignment.
So way back on 24/2024.
That is latest report, my lord, 1930.
Contract. 24/2024. Terminate the contract by taking because of course.
Yes, because they didn't want to terminate, because if it is your default, why they didn't want to terminate on that clause.
No, they have
So you could have always availed of the arbitration clause. Is there any arbitration clause?
arbitration clause is there, but that is also the premature at this stage because these kind of questions have been raised under 63, they have to take a decision. They have not taken any decision.
But now you see this page, in this page 19/5/2025.
Right.
No, this.
19, because after filing of the decision,
No, but they have now said, you see that, you see this number one. They say that your close traversing survey report. But you have you have not given a copy of this to the petitioner.
Because yesterday's notice, my lord.
Correct,
I
but
think
then
they
you have to communicate to the petitioner.
After they can solve by just to perspective to the project.
And
Maybe.
What I want, my lord, to take the decision, my lord, on my representation 7/5 and 9/5
my lord, 7/5,
and give a decision. That's what we.
Yes.
my lord, notice dated is 8/5, my lord, first note, 7 days notice, my lord. And that has been, it is, instruction is, sir.
My lord, the subject matter of this case, my lord, is premature. There is no termination taken place. 7 days notice issued. 48 hours notice has also been issued, my lord, which has not been
Which
annexed.
is ending tomorrow. Which is ending today
Yes,
or tomorrow.
Right.
Tomorrow.
my lord, in fact, what transfers from the fact, my lord, is that 2022 itself work was stopped. Nothing was happening after 22. Today, they are coming and raising a dispute when we are going to terminate. The railways have been constantly writing them to please resume the work. They are not resuming it, nor they have taken any action to continue the work or to maybe foreclose the contract, saying that they will not be able to
He said
perform.
that last year they have written a letter to terminate the contract under clause 61. Force majeure clause.
Yes, force majeure absolutely.
They have extended it.
And as on
up
the,
to 31st of December 25.
that,
For not for complete default, contractor. For the fault of the railway or for.
so admittedly, there is an extension of contract as admitted by them, 31/12/2025. They have extended their BG also. Contract is also existing. Now, their prayer for foreclosure, if it has not been accepted by the railways, well, it is a dispute which has to be adjudicated before the arbitrator. Because what will happen, my lord, by applying the force measure, they want to save their bank guarantee.
Correct.
Otherwise,
Correct.
my lord, the course of action for the railway is that if the contractor has not performed or failed to perform, the termination, consequent of termination is the forfeiture of the BJ and the security deposit. That is what they want to save. And they want to get their money for the remaining work done. Now, this is a dispute, and my lord, in my lord's judgment, one of the orders, my lord, has clearly held that this matter should go for arbitration. This is my lord's judgment. But there it was a case of termination. Here even termination has not taken place.
We are committed that we will be by the end of this month. Until 10 days.
If they want to work, there is no dispute. They can give the reply, my lord. We can continue.
He
with the
say,
contract.
see, you come to page 54. Page 54, page 55. Come to page 55. The third last paragraph, just after that clause 4, with the completion of all the above spells. We are intending to recommence the works in the last week of May 2022.
But they have not replied to the 7 days notice and 48 hours.
Yes,
They should have replied. to
have,
that.
when is your reply?
Your letter.
It is, this-
Page 55.
no, 7 days is of 8/5.
Yes.
This one is of,
7 days.
this is 7/5. Your page 55 is 7.
7.
And then notices of 8 the next day. Notices of 8, page 56.
Yes, page 57, we have submitted reply.
56 is, yes.
9/5. Immediately next day.
Yes, page 57, they have replied. Take a decision on this. By taking into account this, though this letter, though this document of 19/5 appears to indicate that they have made a report with regard to the wrong alignment, according to Ms. Agayan. So mention it, but this letter is addressed, no, it's not addressed to the petitioner. They take a decision, then you do whatever.
Malad, thereafter, a 48-hour notice has also been issued.
This notice has been issued,
Nin-
but that
90
was yesterday.
Yesterday, yes, Malad.
Has it been given to him? Whether he has received it?
No, that I don't know, Malad.
You think, so whatever you take a decision,
No.
on this, I think, you take a decision on his page 55 and 57. Okay, right. So we'll dispose of the entire matter. Correct.
One thing, Malad, that since 2 years, 3 years have passed by, since then they have not worked. If we give them a chance to cure that defect which already they have done. And now we already have given 48 hours notice. After the 7 hours notice, we have considered this reply. And
You've considered his
we have
reply.
considered and this then 48-hour notice is given.
Yes, sir, you have considered this,
Considered, madam.
page
Madam, we'll see.
55 and
In
57.
in the reference, Malad, 7 days
reference.
notice, reference is mentioned there. Reference, 7 days notice, write this office letter, 8/5, and thereafter, Malad, the reports have come.
No, reference, you see, it talks of the 7 days notice. It doesn't speak of the reply made by him. The
Malad,
replies of,
7 days notice was given to resume the work.
correct,
And reports came, Malad, and then it was showed that no action has been taken to resume the work.
but then you have not, you have not taken a
And this what-
decision. Taken a decision on his statement that he will resume the work in May, end of May. You see, come to page 57,
Malad.
come to the
But
in the
can
clause
be
four,
resumed
but-
after 3 years. That is the point, Malad.
you have allowed him to resume. Your show cause notice is basically asking him to resume his work. So he's saying, okay, I will resume my work. Please
But,
give
Malad, that will be subject to the contractual terms and conditions. We may impose liquidated damages. That, my lord, will
that.
observe.
No, no,
Otherwise,
I'm not going to make any observation.
Madam.
I'm not going to say that he should be allowed to resume the work.
Madam.
I'm just going to say, since you have already asked him to resume the work under section 7, any action sought to be undertaken by you would have to be done after taking into consideration his representation
Malad.
and giving a reply to the same.
Malad.
You have to, you see, your show cause notice at page 56 is a 7-day notice
Yes.
saying that we are giving 7 days notice in accordance with census to make good the progress, failing which census. Now
There are,
he,
yes,
page 56.
yes, Malad. And thereafter,
Then there 57, you come to the second last paragraph, with the completion of co-mobilization. We plan to recommence the work in the last week of May 2020.
Malad.
So last week is next week. Now, without referring to this,
That.
you have given this
Yeah.
48 hours. That's all. So we'll just say that you take a fresh decision, keeping in view this page 57. That's all. 50, forget 55. 57 is of no use, 55 is good. Right. Heard, mister? So let's in a counsel for the petition. Assisted by Mr. G. Khandili. Also heard Mr. A. Gupta for the CDC
Malad.
for all the respondents. Yes, madam. The petitioner's counsel submits that the impugn notice dated 8/5/2005 issued by the respondent number 5. Comma, which has threatened to terminate the petitioner's contract under clause 62 of the general conditions of contract if work was not commenced, should be set aside. in as much as the petition, as much as the respondents have not taken any decision on the petitioner's reply dated 9/5/25 to the 7 days notice issued by letter dated 8/5/25. Next, the petitioner's counsel submits that in terms that the petitioner had, that though the work had been stopped in the year 2022, comma, a new work action plan had been submitted by the petitioner on 7/5/2025, and a closed traversing report, TRAVERSING, traversing report, had been submitted on 12/5/2025. Further, in terms of the reply dated 9/5/2025, the petitioner had planned to recommence the work, contract work in the last week of May 2020. Mr. H. Gupta has submitted two letters dated 19/5, no, both dated 19/5/2025, issued by the respondent, giving 48 hours notice to the petition to commence the contract work, failing which the contract would be terminated in terms of clause 62 of the general conditions of contract. Next point, the petitioner submits that he has not been given a copy of the, submits that the petitioner has not been given a copy of the two letters dated 19/5/2025 till date. Next part. First up, he however submits that the writ petition can be disposed of if a direction is issued to the respondent to take a decision on terminating the contract of the petitioner after considering and taking a decision, after examining and taking a decision on the petitioner's reply dated 9/5/2025 in response to, submitted in response to the 7 days notice dated 8/5/2020. Next part.
Followed by subsequent modification. 10/5/25 and 14/5/7. Page 59.
Forget it. One is enough. Next. I have heard the learned causes for the party. On perusing the 48 hours notice dated 19/5/2025. No, and the letter dated, and another letter dated 19/5/2025 issued by the state respondent, wherein the respondents are contemplating rescinding the contract under clause 62 of the GCC. This court finds that both the said letters dated 19/5/2025 has not made any reference to the petitioner's reply dated 9/5/2025, wherein it has been mentioned that he would be planning to recommence the work in the last week of May 2025. Next part. No, first of all, though the council for the council for the respondents had submitted that the petitioners close traversing survey report had been made in relation to a wrong alignment pertaining to tunnel T-25. And this court is of the view that unless the said issue is clarified by the state respondent by way of an order which is communicated, by way of a document which is communicated to the petitioner. It might not be proper to terminate the contract work. Accordingly, the respondents are directed to take a decision with regard to the petitioner's reply dated 9/5/2025.
Fresh decision.
Huh?
Fresh decision.
To take a fresh decision on the petitioner's, where's the fresh decision? There's no old decision on.
No, since now they have given the 48-hour notice. It has, my lord, crossed that stage of 7 days notice as per the.
But
contract.
here,
Now-
but
My lord,
but
direct-
this 48-hour notice
My lord.
nowhere refers to his reply.
No, my lord, the point number 1 is, my lord will see, proper close transversing survey report having correlation of approved alignment of tunnel T-25 as well as alignment of as-built alignment of tunnel 25 is not submitted. This was not submitted. In the reply, they have stated, my lord, that the close transversing survey has been successfully completed and we expect the report to be submitted on or before 10
So
minutes.
that is why I said, you have to read the whole order. His letter is of 9/5.
Yes.
The close traversing report was submitted on 12/5.
Yeah.
You see,
No, this report is of 19.5, my lord.
huh?
19.5.
This is your, no, this is not your, this is not the
48-hour
report.
notice.
This is your communication of 19/5.
Yes. Now, in the report, my lord, will see in the serial number 2, it mentions about, the second page is the report, my lord.
Where,
The second page,
where is your close traversing report? Let us see which is the page.
page 66. The 12.5. 12.5. Report of the HN is of 19.5.
This is what date? 12/5.
So, and this report is of 19.5.
So whether this has been considered.
Yes,
we don't-
yes, my lord, it has been considered. That is why, my lord, in the next page, the first paragraph which I have.
Okay, and that is why they cannot be allowed to do the, so there's no point, you cannot start the work on a wrong alignment.
In the paper, which portion, of it, because they are not, most of us in report have been done, it's done by third agency and we will give it to them. If some deficiencies there, they'll point.
What have I said?
We'll definitely correct it.
No, we'll tell you, clarify, and then just till a decision is taken, no action should be taken on.
On the
That's all.
48, yes. Fresh decision, we will give a detail.
What have I said? It is clarified and communicated to the petitioner. The 48 hours notice dated 19/5/2022. It has been submitted to the court today. Should not be acted upon. Accordingly, the respondents are directed to give a reply to the petitioners. Give a communication to the petitioner's reply dated 9/5/25 and the close traversing survey report dated 12/5/2025.
Also, the subsequent meeting.
So first time, no, that's enough, that's it, first time.
Detail, ma'am. That's one. Detail.
Till then, the 48 hours notice which has been submitted today, dated 19/5/2025, issued by the North Frontier Railway, issued by the Deputy Office of the Deputy Chief Engineer /CON/Imphal Roman 4, NF Railway Imphal, shall not be acted upon. The said letter is also made a part of the record and marked as Annexure X. The said letter and the other letter both dated 19/5/2012 are marked as Annexure X and marked as Annexure X wholly. Made a part of the record and marked as Annexure X. The writ petition is accordingly disposed. We just supplied a copy of the, no, both copies are there. Both. A copy of Annexure X, the copy of Annexure X collectively has also been furnished to the council for the petition today.
Till the decision, which is already Malad has,
Huh?
till we decide,
Yes,
Malad has
Should
already
not be acted
stated
upon.
not be acted.
here decided and communicated.
Yes. 8/5 as well.
8/5?
8/5 only.
8/5 is the notice.
Notice for 7 days for terminating the contract.
Okay, 8/5 also sure. It's also the 8 days notice dated 8/5 and the 48 hours notice dated should not be acted upon.
8/5, my lord, we are already going to take a repress decision. That will not be.
Anyway, let it be there. Okay.
Obliged.